Yeah, Accelerating Technology Readiness Program. Well, what's it all about? I think, if there's one thing that brings us all together that I hear consistently every time I go to workshops, like, for example, some of us went to the M-Cells workshop just recently to kick off for a new cluster at UBC. And it's generally this common concept that we want to basically, improve sustainability. We want to, from petroleum-based solutions to carbohydrate solutions, as we say, or renewable solutions. And I think that's what's super exciting. And the good news is that we're making good progress. And I just thought we'd put some progress up here already. Some of you may or may not know about these groups. These are companies that have come out of BPI, what we now call BPI. I mean, before it was called the Pulp and Paper Center, but now we tend to refer to it more as BPI. Performance Biofilaments, you may know about. They were housed for about 6-7 years at UBC in the Pulp and Paper Center, working on a variety of things, but predominantly, of course, is leveraging microfibrillated cellulose. And as you can probably see in the slide, there's a whole number of application areas, and there's now is really starting to get some really good traction. You can see down here, they just recently spent $28 million building a plant to kick that off. So it's super exciting to see that we're replacing petroleum-based solutions with renewable-based solutions. Another recent one is Bioform. Some of you may or may not know about Bioform. It kind of came out of Mark Martinez's lab. Also doing the same fundamental thing, basically using replacing single-use plastics type solutions with a combination of alginate and cellulose. Super cool. They just got another round of funding, so they're super pumped about that, working towards developing their their pilot. Simple Fiber, this is Orlando's handiwork, and Izu, if he's here today, was quite involved with it, and there were some other people. But super exciting. Here we have a scenario where we're actually going to be producing shoe tops, and you can see here this is Reebok. Using a cellulose-based solution. So solutions are happening. And super exciting. And, just to kind of give you a sense of where we are now with projects, we're working on a variety of things in the ATR program. Some of you here are involved with this, but this one's a wood leather. Literally, it's made out of wood, and it kind of has a texture like leather, and there's a lot of unique, cool applications that I think we can do with that. This is another one. It's aerogel, cellulose-based, super light insulation. And the list goes on. And there is another group here. Actually, I don't know if the folks are here from the 3D mycelium solution, but it was certainly talked about in the M-Cells discussion that we had yesterday. Very exciting in terms of where we could go with mycelium and bringing that together with cellulose. Zhenxing and team here are also working on using recycled cardboard to create a cushioning foam. So that's super exciting with Teo. And of course, lignin particles, lots of exciting opportunities there. So just to kind of give you a bit of a flavor that things are actually happening, and I'm sure many of you already have lots of other additional innovations that already are potentially working and connected with the ATR program or could be potentially connected with the ATR program. So super excited to hear about that. Super pleased to be involved and support in any way we can. So yeah, what is the... my computers decide to freeze. How come? There we go. So what's ATR all about? So it fits into this bigger picture of what's going on at UBC, and some of you may or may not be aware of some of these programs. And I'm going to skim through this, but the deck will be available for anybody that's interested. So we'll make sure the deck's available. But we're fitting into this space here, basically, which is kind of working on the proof of concept, prototyping, pre-piloting, and in partnership with all the other organizations. And so, like UILO in today's discussion. So that's what that's about. Maybe another way of looking at it is kind of we're plugging in this sort of from applied research all the way over towards commercialization. We're fitting in this space here too. And here's yet another way of looking at it, where some of the more specific things that we might get involved with is helping to define specifications. So really understanding early on in the process, what are the technical specifications that are going to be required for this to be commercially successful? What does it need, in order to work? And of course, work towards creating those things and ultimately pilot prototypes and performance evaluations. So, yeah, and then these are the type of things that we might sort of tangibly get involved with. What we're currently supporting on. helping to bring in expertise, and we try to support the projects. And I should say as well, actually, this is not a program in a normal sense where there's a start and there's a regular meetings, all that kind of stuff. It's really more about working with each project very uniquely in a bespoke way, and working with each team, trying to figure out what needs to get done next, what's the most important thing, and working on a step-by-step basis. So, which market to get into, da-da-da. So I don't want to read this. I just want to let you guys get it. And sort of how do we do it? Well, basically, there's kind of what we call a stage gate process that we work through. This is actually predicated on Sergio Bretta. Some of you may or may not know he's a professor in chemical biological engineering, 25 years experience in commercializing technology. And, fundamentally, you're kind of looking at, is there potential? Is it viable? Is it de-risked? Is it ready to go? And in that context, we get down to even one more layer of detail where we talk about specific modules that you would need to ideally complete for each one of these sort of stages. This is the stage, this is the gate. And we work with the teams or the projects to kind of work through each of these specific aspects. And these are often working documents, working parts of the project that evolve over time and become more and more refined as you work your way through. So, you'll start with maybe a preliminary sort of technology-based assessment, but then you'll kind of further refine it as you go down the pathway. So that's just kind of the general quick 5-second, feels like 5 seconds, summary of what ATR program is about. In essence, we're here to support you as the innovators, to support the technical development of the project in context, in economic context, and in context of other support programs that are available at UBC. So, good. So today we're focusing on this specific kind of module, which is around IP assessment. And certainly interest is to make this as interactive as possible. So certainly feel free to raise your hand, ask questions along the way. And over to Austin. Thank you, Austin. Thanks. Sure. I'll just set this up for you.
Sure. All right. Hi. So as Richard mentioned, my name is Austin Lee. I am a Technology Transfer Manager at Industry Liaison Office here at UBC. Today I'm here to talk about Introduction to Intellectual Property. So a little bit about our office and introduction about our office. So we, Industry Liaison Office, now we're going to be merging in with E at UBC people, but today we're comprised of two groups. So one is the technology transfer, which is the group that I belong to, and then our colleagues that sponsor research. What we deal with is with the intellectual properties that come out of university research. What that means is precisely any graduate level research or above. And if you guys have cool inventions that are coming out of your research project, whether that's going to be a master's, PhD, postdoc, and so on and so forth. And if you would like to monetize, so i.e. make money out of your invention, you want to protect or you want to figure out how to protect your intellectual property, or if you want to create high impact societally through commercialization of those IP, then you might want to talk to us about how to do that. That's basically what I said. So how do you engage with us? Well, one is that you can send me or other colleagues of mine an email or call us or get Richard to send introduction to me. Or a better way is that if you have those cool ideas, you can actually go to our website and follow this prompt or you could just actually Google UILO, tell us about your invention. That's how I usually go to this website. And then this website will pop up in the first thing in the Google search. And you'll just follow the prompt here, and you'll see that there's a link to online disclosure form. This is where you submit your invention disclosure. All you have to do is just log in with your CWAL, and fill in the prompts. And it's very easy. Fill in the blank process, and then we'll come and talk to you guys about learning more about what you did in your whether it's your again research project or other cool ideas that are affiliated with UBC. Then we'll do that assessment with you by learning about your invention, doing some prior art searches through literature, giving you maybe a little bit of education on what we consider as patentable invention versus maybe there's other ways of protecting that IP. Also, if you have any questions or want to connect with more resources, especially later down the road when we were merging in with the UBC people, whether you want to start a venture around your research project, then and you wish to protect that IP and you'll get some more support around that startup journey, then you would also want to talk to us through this forum. As Richard mentioned, Bioform is being kind of one of the very successful technologies that might be relevant to this group, wherein Jordan and Mark have talked to us. I still remember that first meeting that I had as an officer, and I was working with the mentor at the time, and they were navigating this process. How do we start a business around my project here? And long story short, several years later, they're a really successful company, raised a lot of money, and they're doing these really cool alginate-based 3D printing at a scale up to address these market challenges in renewable packaging or multi-film manufacturing. So, and the intellectual property behind all these cool commercialization effort is being licensed from UBC, from our office. So that's one cool example that has spun out of UBC recently. So this is our IP 101 topics. I'm going to start with some true or false questions about patents. I'll get into then what is an intellectual property, types of IP, there's 4 types, and then I'll get into some more details about patents, which is the primary kind of type of IP that we handle most of the time. And then I'll touch up on the anatomy of the patent application and how to search for a patent application for your own reference. All right, so let's see how this goes. So if I have a patent, I can practice my invention. Who thinks this is true? Put your hands up. Okay, quite a few people. So what about false? Do you think this is false? Hands up. All right. So rest of you are kind of, you don't know, or is Austin tricking you to brainwash into some? Is it true or false? No? All right. That's fine. Second question. Once I have an issued patent, the government takes care of infringers. Is it true? Okay. Who do you think? Who thinks this is false? Most of the people. Okay. So you know that the government's not going to take care of infringers. And that's actually true. This is not true. So I can get into more of this later down the slides. But you're right. It's government does not take care of infringers in any patent infringement lawsuits. Once the patent office issues a patent, I know that means it has commercial value. True? No? False? I think this is actually true. Patent has a commercial value. Yes, it has some commercial value. Because you can take a granted patent, issued patent, and you can impress your investors and raise more money for a commercial endeavor. You can also have that as an asset, for your business, and it's a way to justify the valuation of your company. It could also be that business tool where you can push off all your competitors in the relevant sector. So it does have some commercial value. So that I would say is true. Okay, all I have to do is file a patent application and I am golden, no worries. True? No? So everyone thinks it's false? Who thinks it's false? Yeah, okay. Yeah, this is false. Owning a patent is the only way we can start an innovative business. True? True? Okay. Who thinks this is false? Yes, I would say that is false. Patent is not a must-have tool, although it'll be very useful if you have useful business. So turns out that, well, including the first one, everything else is false except for the third one here. At least this is my opinion. So maybe we can come back to this if we have time. Once I have gone through this lecture, maybe we can kind of know why that would be the case or why not. And we can have discussion if we have time again on these topics. So let's start. What is an intellectual property? Some people say it's creation of mind, a currency of knowledge-based economy, major value of company. These have some truth to this, but at the end of the day, what the business or legal people would define as intellectual property is just like a property, like a real estate. It is an asset, but it's an asset that you cannot touch or feel. So it is, it is a really good, again, tool to justify a valuation in your business. But then it is something where you can't really quite touch or feel. So it's not like you can just sell your patent or sell your idea to somebody else for $1 million and expect that that person is going to actually pay you $1 million for it, because they would not be able to perceive what that intellectual property is, because they can't touch or feel or see that asset. There's 4 types of intellectual property: copyright, trademark, trade secrets, and patents. I left the patents in the very last because that is the most important from the context of our office. Copyright, this is one of the easier kind of type of IP that you can obtain. It's very low cost, even for registration. I believe it's in the range of $50 to register. It's easy to obtain. You actually don't need a registration, formal registration for something to be copyrighted. This includes essays, artwork, music, photos, and also software. The duration of the copyright is, it depends on jurisdictions, but typically it's 50 years after the death of the author. So it lasts a very long time, and some of the copyrights can be very powerful and very valuable. So one example would be like a Taylor Swift song, Beatles song. These things have, they're making literally millions and millions of dollars on royalties, and every time that you play the song in a public space, they're always taking that royalty from the use of that copyrighted song. The cons of that copyright is that it protects a very narrow range or narrow scope of an intellectual property. So if we're talking about, for instance, a software. I'm going to give a very hypothetical example here where if let's say, somebody had access to source code on, PowerPoint presentation application, and if you were to, change enough of the lines in that code, and then it kind of converts to some derivative works of that PowerPoint slide, then you all of a sudden might be creating a new form of copyright. So it can be very easy to bypass copyright depending on what type of copyright it is. Of course, it's not going to be that easy for so I would not attempt to copy, modify these sort of famous software like PowerPoint slides or anything like that. But and that's sort of the it can be the narrow scope of protection. So unless you have a very strong commercial standing, it's going to be very hard to protect that copyright. Trademark is logos, word, symbol, and those things that can differentiate your product between your companies or your own sort of shoes or clothing or food products and whatsoever from your competitors. So it's like Nike, Levi's, Rolex, eBay's, or any sort of famous brands or logos of that would be considered as trademark. Trade secrets, as the name secret implies, is a secretive information, a confidential information that only certain group of people know about, and that it is something that's not supposed to be in the public domain knowledge. So these are typically kept in a super secretive chest under some deep confidential agreements in some of the corporate examples, and so they can be subject to any sort of leakages would be subject to very critical consequences in any sort of business transactions. So examples that are known, or at least in the myth, is Coca-Cola recipe or KFC recipe. These are something that some people might say that, only 4 people in the world know about the actual exact recipe of KFC. Well, I don't know if that's true, because I have no access to that information, or who owns or who has access to that information. But those are examples of trade secret. And it can last as long as the people that have access to the information keeps it a secret. But once once one of those people has leaked that information outside, let's say in the public, presentation like this, or if you publish your findings, etc., then that secret is now not a secret anymore. So in university setting, trade secrets are not usually a form of IP that we would consider, because we're here to actually disseminate the knowledge. That's our first mandate. And so it's going to be pretty hard, if not impossible, to keep certain things a trade secret forever, at least not until you decide to publish. Until you decide to publish, then it becomes a public knowledge. And last but not least, the patents. So this is all basically copy and paste from the WIPO, the definition. This is an actual definition of a patent. But what's important is actually, I would say, this is the second point here, where the patent right is actually a right for the patent owner to have an exclusive right to stop others from using that technology. So if I had, sorry, Richard, I have a patent on that glasses that Richard has there, and then if I had, and then I can actually stop Richard potentially from using that commercially, or stop Richard from selling it, stop Richard from making it, stop Richard from distributing it to other people. It's not, so there's a very subtle but yet very important distinction in that, where it leads to kind of that first question, our true or false, where if I have a patent right for that glasses, for instance, it doesn't mean that I can commercialize that glasses. It just means that I can go after people that are practicing that invention. So it's a very inhibitive, kind of negative right, in a way. The sort of a philosophy behind this is that the government saw that there are these very smart people like you guys are continuously innovating and creating new inventions, and that they would like to, government's mandate is always the betterment of society, and they would, in order to encourage the inventors from disseminating their knowledge and various know-hows, they created this patent law where they actually are granting you the right of monopoly of the things that you've created as an invention for about 20 years or so. In return, that you are actually then supposed to give all the know-hows how to make your certain devices, or detailed sort of methodologies and various know-hows that are associated with method of making things, or even composition of matter, such as like a new material or pharmaceutical compounds and et cetera. So in exchange for that information to the government, you're getting that monopoly right. Again, that's by having that legal right to stop others from using your composition of matter, apparatus, method of making things, etc. So a good example of that is if I had a patent on automobile or critical components of that, then I can go after Ford, GM, Chrysler, who are manufacturing these automobile parts and components, and say, I have patent rights. Unless you have license to my patent rights, you guys are not allowed to make these automobiles anymore. You can also go as far as the distributors or car salesmen and say, well, you're not able to sell these cars unless you have the license to rights. In practice, what happens is that usually for this type of apparatus, like patent rights, then you would actually grant those rights to the manufacturers, and who are able to also distribute and sell their automobiles, and therefore and in exchange for obtaining royalties and etc. Patent lasts about 20 years. When I say about, it varies from case by case slightly, depending on some of the subtleties in the way the patent law is written in various jurisdictions. But just know that since the filing of the first provisional or any other patent application, your intellectual property will last 20 years. So it does have expiry date. So that's kind of the basics of sort of intellectual property and patents. How do you get a patent? So one of the basic criteria is that, well, it has to be patentable from the perspective of the patent examination office. So that would be, in the U.S., it'll be U.S. Patent and Trademark Office. In Canada, it's the CIPO, or Canadian Intellectual Property Office. And there's counterparty offices in various jurisdictions in Europe, China, Japan, Korea, and etc. And what they look for as a criteria for patentability is 4 things: subject matter, novelty, inventive step or non-obvious, and industrial utility. The first and fourth is pretty easy, well, fairly easy. The subject matter is basically you have to claim an invention that has some human intervention component to it, so you can't really file a result or outcome of certain findings as an invention. It could only be things like device. It could be a method of making something. It could be a new material or a composition of matter. But it can't be mathematical equation. It cannot be natural phenomenon. It can't be. I tested my aerogel characteristic, and then my aerogel got mechanical strength of X. Those are the things that you can't file a patent on because of the subject matter concerns. Utility just has to be, certain invention has to be useful. So for most of our research contexts, we're doing something useful. So it's pretty easy criteria to overcome. The other two are always going to be the most contentious. So first one being novelty. So your invention has to be new in the view of public domain knowledge. And the second one being inventive step, or your invention shall not be obvious in the view of the public knowledge. So novelty is, I think, in the current societal context, is that if any of your features of your invention or description of invention is Google searchable, that probably means that your invention is not novel. It could also include any public presentations, such as conference proceedings or any other means of disseminating that knowledge as a public domain. So then the patent office will view that as okay, your knowledge is already in public domain, therefore your content here or your subject matter here is not novel in the view of those prior art. And oftentimes in university setting, your own sort of past presentations or your own publication, your thesis defense, those things could actually be a very common way of losing that novelty ground. So we'd always, our office is kind of a common sort of thing to deal with is how do we work with you guys to make sure that we don't lose that patent right while we don't stand in your way of publishing your work, or you need to graduate and you need to present your thesis, but you can't do it because URL wouldn't file a patent. Well, we don't want to be in that situation, so we will always work around you to make sure that you get the maximum rights possible at the given circumstance, of course, with some limitations to that. And another way of, so the most ideal way of protecting your invention against the novelty ground is to file the patent application before any of this public domain knowledge has become public. Another way of doing it is if you're having a specific discussion around, maybe it's a research collaboration or industry commercial potential discussion with, let's say, an industry partner or other organizations, you can actually enter into confidentiality agreement, or more commonly known as non-disclosure agreement, where any information that's shared within the context of that agreement is considered as confidential. And this is one way of addressing that novelty concern if you're having specific discussions. And our office has a pretty nice automated template for generating that NDAs. So more on that if you have any further questions or inquiries on that. And then last but not least, the inventive step is or obviousness. So in the definition here, it basically says, if a claim that you are trying to make is obvious to a person skilled in the art to arrive at something falling within the terms of the claim have regard to the art known at the time, then you will not be granted the patent rights. What does that mean? Well, so I have an example here. So let's pretend that, we have paper clips that's already known and somebody filed a patent on it and it's a public domain knowledge. And let's say I came up with a paper clip with ridges on them. And you might ask, well, is that invention obvious in the view of this paper clip? So here, you can actually be argued on either way, right? Because, if these riches might seem very like a common feature in any office supplies or any sort of similar supplies in the field of this classroom setting or whatever. And if you find, let's say, a pencil that has these similar rich features so that people can, grab onto the pencil or pen with an ease, and then somebody can argue that, well, I can take that rich from pencil example, and then I can just stick that onto this plain old paperclip, which is already known in public domain, and I arrive at your invention, and therefore your invention is obvious. And then my job as a patent, trying to get a patent on this riches, no, you could not do that. You could not, anyone who's skilled in the art of making or commercializing the office supplies would not have thought of combining the pencil example, the rich feature, to applying that into the paperclip. And so then you can see that, well, that argument can be very subjective. And that's, there's some guidelines on how to view certain things more obvious than others. But at the end of the day, yeah, it is pretty subjective, and it's kind of open to a bit of a negotiation with the patent examiner at the time of prosecution of your patent application. And it also depends on how you word your claim. So it's always important to have a patent agent or a patent lawyer who's really good at wording the claims, the way that it sounds more inventive, and also has that skill set and the domain knowledge to argue that something is inventive over, your invention is obvious in the field of hardware, or your invention is obvious in the field of forestry, or your invention is obvious in the view of material science, and so on and so forth.
Awesome.
Yeah.
So in practice, how does this actually work in the context of a patent office? So,
Yeah.
we file a patent, say for Canada, for example.
Mm-hmm.
So, and there's an examiner. So is this examiner theoretically should be knowledge domain specialist, knows the area, but would they also then connect with other patent offices globally to kind of say, by the way, I'm looking at this, do you know of anything like that? How do they know whether it hasn't been yet curated somewhere else in the world at this around the same time, or, and what's novel, what's not novel?
So the short answer is no, the patent offices don't talk to each other. So you could actually have, and the tricky part is that the interpretation of this obviousness is different in, let's say, European patent office versus US office. And we know that the European office has much stricter definition or interpretation of what the obviousness could entail. Same with other jurisdictions like Japan, and other jurisdictions. And then some other jurisdiction might have a narrower definition or easier time of something arguing over the obviousness ground. So that actually means, and this becomes a very interesting IP strategy question, is that you might actually want to focus only on getting a US patent because you think that your claims can be argued as an invention in the US, but maybe not in the Europe or other jurisdictions.
So it's possible
that
you could get a patent in the US,
but not in the Europe or other jurisdiction. Okay. It's very possible. In terms of, do we have a guarantee on, I'm sure that we're going to get US, but Europe is going to be tough. It's very case by case and very subjective. So you'd have to, and also in some way it's very examiner specific as well. So you kind of have to just face it and then see what examiners would have to say, and then you sort of figure out how to rebut the argument, or maybe you want to negotiate a new amended claim set, and so on and so forth. So it's a very long haul sort of, kind of dragging on different, going back and forth with, it's like a manuscript review process in some case, right? It's you submit or you did some nice science and then you think this could be published in Nature Science or Advanced Materials series, and then the reviewers will always turn you down and say, well, yours is what? Not really interesting to me. And then you're supposed to argue like why your science is interesting, or maybe sometimes they do bring up really good point on some of the errors that you might have made, or maybe you forgot to do your control studies and so on and so forth. Sometimes you have to go and do those additional experiments or address those concerns from the reviewer, and it's similar to that process. You have to argue with the examiner sometimes that you're misinterpreting my art, or sometimes you say, actually examiners got a good point, and I would like to address that point by amending my claim and say, hey, you're right, but then what about this claim here in my set of claims that might seem more inventive than the first proposal that I have had. So yeah, it's an iterative process. Yeah?
Just following this question, so like Richard said, if, for example, the patent is accepted in the US and does not pass the European patent, so in some people, in Europe, they replicate this recipe or products.
Yes.
Can they still sell in Europe without?
They can manufacture, sell, distribute in Europe, but they cannot sell, manufacture, distribute in the United States. So in the case, so practicality, so that's the technicality of the patent law. But the practicality is that if you're innovating in the high-tech business and if you want to sell high-value products, chances are you're selling some of that product in the United States. At least 30-40% of the revenue, I would say, if not more of that, should come from the United States because of the current status of their economic power. And the old kind of saying is that when you make a cool invention, there's always going to be some Americans who's going to buy that product. So do you want to leave out the U.S. American business opportunity because you have no patent rights in that? Or do you want to negotiate a license agreement with the patent owner and say, hey, I want to actually sell this product in the United States. Can we come to an agreement? I would say that is usually the smarter answer. But it's all basically case by case. I mean, some reality would be, I would say, yeah, some products they might stay domestically, like if it's a local like Chinese invention or a German invention or whatever, and then if they want to just do the business only in their country, I suppose they can. Yeah. Any other questions? Yeah.
Just on patents, like how specific or now so like I'm just thinking like back in the day before cars were invented, could you have been like anything with like 4 wheels that rolls? That's my patent. Boom.
Yeah, it could have been. So back in the day when there was not a lot of public domain knowledge, yes, they probably could have gotten very general claims like that when there's no device whatsoever in the world that runs on 4 wheels. But in the modern world, reality is that there's plethora of knowledge and technology that's out there. So kind of that old way of thinking about patent claims being too broad is not as applicable in today's world because if you make your patent claim too broad, hoping to get that broadest claim and then going after all these infringers that are really nice, yes, except that, well, you're going to be faced with all these prior art that's out there. So if you describe any apparatus with 4 wheels on them, well, somebody can actually take a reference from a bicycle that just happens to have 2-3 wheels on it and say, well, your invention is already described here. Make an argument. So it's usually not. Yeah. Yeah.
Like with the obvious, so say you see something in a movie and it's like laser guns or something.
Yeah.
It's obvious to
Yes.
So,
Yes.
put a patent on like laser guns?
So that's a very good question. So the question was, can you see, so I'll just maybe elaborate that. So if you see a Star Wars movie and you see a laser gun, can you patent that and get a rejection based on the fact that Star Wars already described laser gun in their movie? The answer is yes and no. So if you just describe the laser gun and say like, an apparatus that shoots laser, and then if you haven't described anything, how you would make them, how you operate that device without breaking it, how to not safely operate, for instance, then it's going to be really hard to argue against the Star Wars reference. Whereas if you say, none of the laser gun references have described, how to control the power of the laser with my special little device that hooks onto my gun, or it could be, the gun has to shape in a certain way, or that I had to come up with a new design to, focus on the laser so that I can actually shoot and kill someone. Those are kind of the nuggets and nuts and bolts of, what the sort of patent claims would be. And as long as those specific features of that invention has not been described in Star Wars movie, you can get a patent on that. So it's about it's a very good question. It's about not having kind of idea, I can fly a monkey to the moon with my rocket ship. It's actually about coming up with, how do you build that engine? How do you make sure that the rocket doesn't blow up into space and that sort of thing? So those are all the hard work that you're doing in the research lab and saying, well, I did this experiment and then things didn't work out, or my thing just turned into jelly and then it wasn't and then you had to add some other component to it to make sure that it actually has some desired property, like creating an aerogel or creating wooden leather and stuff like that. There must be some sort of a know-how that makes your invention possible, and what is that feature going to be? And those are kind of the things that we focus on in evaluating what something is a patentable invention or not. Yeah. Talking about money. So getting a patent is expensive. It can cost up to $20,000 to $40,000. If you want a patent in the world of variety of jurisdictions, it can cost hundreds of thousands of dollars. It's also a time-consuming process where, since the filing of your first provisional application, it can take up to typically about 4 to 7 years in getting a patent issued. So there's a full-on business project management for each case for us. And so, our job as a technology transfer manager is, okay, like how do we manage our budget for each case? Because you can see that throughout UBC research, there's thousands and thousands of ideas, and we have to somehow manage our limited amount of money and time that we have in terms of, okay, what are some of the patents that are really worthy of spending our money versus maybe these are not something that's patentable. So that's why we go through a lot of scrutiny on what can be patentable and what can have a big opportunities in future. And this is one of the examples where we can sort of try to evaluate those opportunities for each and every intellectual property, for each sort of IP event, for instance. And we don't use this template anymore today, but this is something that kind of technology transfer officers and managers will be thinking about back of their mind, is that when we file the first provisional, it usually doesn't cost a lot of money. It's like you can slap a manuscript and then you can say, well, we have a placeholder. But then once you go to the sort of the later stages of the filing, your costs of or the commitment to execute on those filing processes and/or prosecution, maintenance, and other costs that are related to patent is going to exponentially increase. So as they go to the next step, we're going to have more scrutiny on one is, well, is this technology really actually patentable? Two is there a big enough an opportunity? And then we have to then do these kind of assessment, almost like an iterative project management sort of a fashion. So, and this is another kind of myth about patent is, and what's really substantively different than academic manuscript to journal article production is that you would go through maybe one or two of rounds of review process, and then you'll finally publish your paper. And similar to kind of your thesis, I mean, it's a daunting and very scrutinative process. But at the same time, you publish it once, and then you kind of forget it. And then that's published. And it's great. And then you work on some other project. But patent doesn't work that way. Patent is you file something, and then you sort of monitor the progress of that innovation, where it's going, whether it's got a big enough opportunity. Do you have a startup opportunity therein that's created, and so on and so forth? And those, all these factors will dictate whether we want to continue on with pursuing that patent filing opportunity, or do we want to let it lapse and maybe focus our efforts into other sort of intellectual property for opportunities in the future. I'm just looking at the time, so I don't know if I should stop here or yeah. Yeah. I'll just race this down. So freedom to operate. So coming back to sort of the paperclip example, just because I have a rights to, let's say I get a granted patent on that ridge feature of the paperclip, does not mean I have a freedom to practice that invention, or I can't just go out and sell this paperclip with ridges unless I get rights to the plain old paperclip if somebody actually had owned the patent application on that. And so kind of irony in patent world is that actually, let's pretend Richard has, owns the plain old paperclip, and then I own the ridge feature in the paperclip. Neither Richard or myself could actually make paperclip with ridges unless one of us actually grants the license to each other's rights of that feature. So, which is kind of funny, because then it means nobody can make the paperclip with ridges. So this is where the freedom to this is an issue of freedom to operate, and yeah, it's actually true. So, and you can imagine this being a pretty big problem with, like, say, for instance, hardware or chip makers, because they obviously have these libraries and libraries of chip designs, and Apple copying Samsung and the other way around. And so you hear these patent infringement lawsuits, and they usually come after each other for multiple IPs. And what ends up happening is that you then either enter into some sort of license agreement, or even a cross-license where each organization might give you license in return of getting the license of the rights from the counterparty. So there's lots of ways to resolve this issue, but just know that the freedom to operate issue does not get solved just because you have an issued patent. I think I should stop there. I'm just looking at, so I have sort of the anatomy of patent application. I don't think it's, so this is something, it's just like a manuscript where you have title, you have some drawings, you have some writings on these details of your invention, and then finally the claim sets. So that's sort of an anatomy of patent application. And then what I wanted to maybe touch up on is that if you want to go find a relevant patent literature to your invention, you're free to do so by visiting any of these websites. My favorite these days is Google Patents. It doesn't provide anything and everything kind of thing. It's, I would say, sort of my own satisfaction. Google Patent does sort of 70 to 80% of the searches. So please check out like Google Patents and do these keyword searches and see if you find any relevant articles related to your, say, you got some research project that you're doing. See what's out there. And then there's all these other tools that people use in, for instance, our office or a patent examiner or patent lawyers. If you want to get them to do a patentability searches, then you can actually do classification searches. So they have actually, the patent offices have very specific classifications, so it's easy to go through the relevant classification of patent rosters, and then you can find like relevant patent application in either international application databases or US patent. Those are two most famous ones. The Patent Center gives you kind of the trace of paperwork on the patent argument. So if you want to find the prosecution history of a certain U.S. patent application, then you can visit the U.S. Patent Center website to see the prosecution history. With that, I'll conclude my talk.